All right. All right.
All
So
right. Can you still see me?
We can still see you,
and you can also see the screen. Okay.
Who am
great.
I? We see. Wonderful.
Yes. Okay. Existential question.
Start with the big stuff, right?
Yeah.
So welcome everyone. We are here today with Shaun Spalding, who's the assistant director over at New Media Rights. He is he and I have been working together at the Rec Innovation Lab at Miramar College, where he's been so supportive and helping the students work on their startups and giving advice and just basically being there, generally being there for us. And I couldn't have done it without him. I am so grateful for all of the help from Shaun, and I'm excited to hear a little bit today from him, some of the basics that every entrepreneur needs to know when starting a new business. So with that, I will introduce you to Mr. Shaun Spalding, who will take it away from here.
All right. So thank you for showing up. Thank you for showing up, especially in the context of the fact that you all have finals. I know that's rough. I see a few familiar faces, so glad to see you all here. A couple of you all know who I am, but for those who don't, I'm Shaun Spalding. I work for a nonprofit. We're called New Media Rights. We are associated with the law school downtown. We provide a lot of legal services for people who are startups, journalists, filmmakers, who can't necessarily afford $300, $400, $500 an hour for a lawyer, but they're doing something innovative or exciting, and we want to support them. And so the areas that we work in are intellectual property, privacy, media law. So intellectual property might have to do with copyrights and trademarks. Privacy has a lot to do with what you can and can't do when you collect data. And media law is things like when can you record someone, and when can you publish those recordings, and when do you need to get consents, etc. So lots of questions about those for pretty much everyone who's creating media. For many people who are creating startups, particularly the kind of startups that Rec is working with and helping foster. And definitely privacy issues. Anytime you're online, your website is collecting data, you have registrations, you need to figure out what to do with that data and how you are regulated or not regulated. So this is going to be a complete grab bag of different issues. I know that some of you all are part of the REC program. Since we're live here, right? This isn't just a recording, but like we are here and we are ready to answer your questions. I'd rather give you a really quick overview and then give you a chance to ask questions, or give you an opportunity to schedule private follow-up, because a lot of questions that you may ask may be so specific to what you're doing that I'd rather not ask in public, simply because there's a sort of confidentiality thing that goes with attorneys answering questions. And so if you have general questions, saving a lot of those for the end, and any specific questions, feel free to schedule a follow-up. Just let you know, we are doing free consultations. You can see this link right here, bit.ly/NMR consult. And so you can go there even right now to sign up for a free consultation. I know some of you all tried to sign up before, but we had limited spaces. So feel free to go there and sign up again. There's 3 different dates. There's the May 29th, there's the June 5th, and June 12th. The one thing that I would ask is that you only sign up if you really, really want to do it, because we don't have that many resources. We're a pretty small organization, so cancellations tend to cause quite a few problems. And so if you can sign up, because there's limited spots, but also know that if you sign up, just sort of make sure that if you do have to cancel as early as possible. All right, so last thing I'll say before the thing is that we also have a book. It's on Amazon. It's really cheap. It's about the types of things that you might be doing at the start of your project. So business formation, contracts, IP issues, contractors and employees, what to do when you get some sort of legal cease and desist letter. And so a lot of the things that I'll be touching on here, we talk about in slightly more detail in the book. All right. Let me see if I can make this larger before we continue. Oh, nope, that wasn't it. That was it. All right. So the first thing I'm going to be tackling is business formation, because this is the issue that I guess everybody starts thinking about when they are thinking about putting together their business. When do I form it? How do I form it? And so for the most part, I think you've probably discussed in passing what the entities are, so I'm going to breeze through it. Formal entities in California include LLCs and corporations. Informal entities include sole proprietorships and general partnerships. And so the big difference is that LLCs and corporations require you to file things and then have administrative requirements. So for example, corporations have meetings that you are required. LLCs have things like starting your own bank account, having an EIN number with the government. Whereas sole proprietorships, you are probably a sole proprietor right now if you haven't ever thought about that, because sole proprietors, all you need to do is you need to start doing something with the intention of making money, right? And then a general partnership is just two people or more doing something with the intention of making money. And so it's not really that useful for you to agonize over these different names. What I think is the most important takeaway is to learn a little bit about the pros and cons of whether or not you want a formal entity or an informal entity. And so I'll be spending a little bit more time with that than just defining what an LLC is or a corporation is. So all formal entities have these pros, right? You limit your personal legal liability. So this is probably the biggest advantage for most people. Imagine for a second that you, as a sole proprietor, are sued. Let's say that you own a house and a car, and you also own a business, and the amount of money in your business's bank account is $5,000. Well, if you lose that suit, let's say it's a $100,000 judgment. If you lose that suit, you might end up losing all $5,000 in the bank account to pay for that suit. But in addition, then someone can attack your car, for example, or your house, and you could potentially lose your house, your car, and all the money in your business's bank account. Compare that with a formal entity, which is in itself a different person than you, if that makes any sense. So imagine a situation where that same suit happened. Well, if the company then loses that suit, the company gives away all of its money in the bank account, but the person who was suing you has no ability to actually take your own personal assets. So your car is safe and your house is safe. And so this is usually the biggest positive aspect of having a formal entity. And all things considered, if you can, you probably should. But we'll talk about that later as to when you should do it and what you should be thinking about as you're potentially thinking about forming your business. There's also advantages for taxes. Both corporations and LLCs have many different ways that you can be taxed. And so you should talk to someone who knows about finances and knows about what you're doing to figure out whether or not there are tax benefits. Accountants can tell you about that. Business formation lawyers can tell you about that. It also, and one nice thing is that it provides a mark of professionalism. Everybody who starts a startup wants to be called CEO, but you're only a CEO if you run a corporation, right? So I think that if your intention is to go for outside investment very early on, if your intention is to provide some sort of sheen of professionalism, then having your entity formed and being able to say, I'm a company, if you invest with me, it won't go into my personal bank account, it will go into a business bank account, and all of the protections that the government provides for corporations and LLCs will protect your investment, right? These are things that investors are looking for, and investors, even small angel investors, will not typically give money to invest money in sole proprietorship just because there's not really very many mechanisms to properly protect that money. All right, so pros of informal business forms. So they cost little or no money to start or maintain. You probably inadvertently walked into being a sole proprietor just by starting to do whatever it is that you wanted to do, right? So you didn't need to file anything with the government. You didn't need to pay any sorts of fees. You didn't need to, you don't need to do anything to maintain it. If you decide that you want to stop tomorrow, you can stop tomorrow. With an LLC, you might have to, well, it's not that you might, you do have to wind down, and you have to tell the government, and you have to do all sorts of things. And so if you want to maintain that sense of informality, you may not want to go to the formal forms yet. All right, and no administrative requirements, so no meetings, no paperwork. One of the things that really sort of gets people in a bind sometimes is the fact that they pay to start the LLC, or they pay to start the corporation, but then they actually don't do the corporate minutes. They don't have sequestered bank accounts. They don't do all the things that actually give them the benefits of the LLC that you need to do. And so they end up spending a lot of money to pay for the LLC, but they don't actually get any of the benefits because they didn't follow the formalities. And so if you know that you just don't want extra administrative headaches because you want to concentrate specifically on doing one or two milestones in your business first, then maybe an informal form is for you. All right, so without necessarily getting into the law or anything like that, I think the biggest question that people ask, and the most useful question to resolve, is how do I figure out if it's actually worth it? Because once you start doing research, you realize it's going to cost $2,000-$3,000 to start an LLC or a corporation. Even if you use LegalZoom, you're going to end up spending $1,000 or so in fees in California. And you also still have to follow the rules. So even if you figure out how to do it yourself, which is not necessarily rocket science, but it's still difficult enough, you still have to do extra research and become an attorney yourself a little bit to make sure that you know all the rules, right? Because if you don't follow the rules, you don't get protection anyway. And so you also have the yearly payments, right? It doesn't stop costing money to be an LLC or a corporation. And so how do you figure out if it's worth it? Well, here's a little triangle. This will tell you exactly, those like triangles where it's like either something's quick, something's cheap, or something's good. Well, this is one of those same triangles. So this is about how to figure out if you want to start an entity. Well, how valuable are your personal assets? That's a big initial question. If you have a lot to lose, then it's a no-brainer, because if you have a house, an expensive house, or a nice car, or investment properties, or anything that is high value and you'd be sad if you lost it, then it's much more likely that it would weigh in your favor to make sure that you have those things personally protected. It seems as if the $800 or so in fees plus the $1,000 or so to pay for an attorney is worth it if you can keep your $500,000 house, right? So then you also weigh that against the probability that things could go wrong. And so not every business has the same level of liability. So imagine for a second that you are, I don't know, selling digital products, like an online course or something like that. Let's say the online course is in something that it's like an online history course, like become well versed in Egyptian history or something like that. That seems like it's very low in terms of probability that could go wrong. Oh, well, maybe someone doesn't like the course and wants to have a refund. So these are all things that clearly there's not much liability there. Let's say you're serving food. Suddenly there's tons of liability there because maybe someone will get sick, right? If someone gets sick, then medical bills could be high. Let's say you're doing healthcare or healthcare advising. Suddenly the probability of things that go wrong are completely massive. And so anytime you have an outsized amount of things that can go wrong, then it is likely that it tips in the favor of making a formal entity as soon as possible. Finally, your willingness to take on costs up front, right? So this is the other balancing point where maybe like a lot of people just don't have $3,000 to spend. And particularly if they do have it to spend, they're spending it on making the MVP for their product, so their minimum viable product that you need to release. And so if you're judging between whether or not you're going to spend money on this administrative thing, like forming your company, or you're going to spend it on getting your product out there and making a profit, most people are going to want to choose getting the product out there and making the profit. And so this is sort of weighing against these other two things pretty consistently. But you also have the value that you get, right? There are other ephemeral values. For example, if you know that in 3 months we're planning on pitching to angel investors, and you know there's no way that they're going to invest in an informal entity, well, then that weighs in the favor of just starting to form it, right? Because it's going to take a little bit of time to figure this out, and so you might as well start forming now. So you're weighing the value that you get versus how much money that these things cost versus what can actually go wrong versus what do you have to lose. Because if you have nothing to lose and nothing will ever go wrong and you're not planning on doing any outside investment and you don't have any money to take on any upfront costs, then maybe it's not worth it for now. But you have to ask yourself, all right, what is now, right? Because the calculus of these three aspects is always changing. And so when should you form it is the next question that usually shows up. And so this is one of those things where, because we're a nonprofit and because mostly for the vast majority of our work is pro bono or extremely low fee, such that every time we help someone, we actually lose money, we don't gain money. We have very different interests sometimes than the typical private attorney you'd talk to. And so if you go to a private attorney and they're like, oh, when should you form the company? They'd be like, immediately, right now. And it's not, and it's for several reasons. One, it's because attorneys don't like people taking on risk, right? And so a formalized entity, if you're serious about it, seems like a proper thing to do. Number two, private firms generally don't work with people who don't have any money, right? So the assumption is that you're coming in with money to pay for this thing, so they're going to say, do it right now. And then finally, there's the profit motivation of, well, I make money when you pay me to form your business, so you might as well just do it right now. And so here is my slightly alternative view of when might be a good time to form your company, knowing that these things are constantly changing. Like every week, suddenly you change your business model and the probability of things that can go wrong skyrockets, right? Maybe your willingness to take on upfront costs changes once you get your first big client, right? And so when should you form your company? Well, here's a proposed timeline of stuff that might happen in your company, right? So product idea. This might be the stage a couple of you are in. You just figured out like, hey, remember socks? I want to make socks that have their own built-in heaters, right? This is going to be great. Like I have this like engineering concept. My friend's an engineer. He has these like heaters that don't break down. Like this is going to be good for skiers or whatever. And so now you have this great product idea, but are you going to form the company? Do you have $3,000 just for your product idea? Maybe it doesn't work. Maybe you realize that you're tinkering with the thing and the socks set on fire 10% of the time, right? If you formed your LLC at this stage, then you would just have wasted your money because you realize that the product actually doesn't make any sense. And then you also have to pay to wind it down, right? And so maybe you're going along the timeline of determining the viability of the product. Well, you're like, okay, those socks didn't actually work. But how about we just, instead of putting in, I don't know, electronic heaters in the socks, we just come up with a better material that keeps people's feet more warm and warmer. So that's your pivot, right? You went from product idea to determining the viability of the product. Clearly not viable, but you came up with another sock product that is actually more viable. Do you then start your LLC? Well, then maybe, right? Like, oh, well, it's a situation now, well, how much money do you think you're going to make from these socks? If you sell these socks and your profit is $1 per sock, well, it's going to take you selling 3,000 socks to pay for the LLC. Maybe you should see if you can sell 10, right? Maybe you could see if you could sell 100, right, before you start this. And so that's going to be another question. And so all along the line, bringing on internal partners. And so now you have people who are, let's say, your business partners. So it's you and an engineer. And so is it risky enough, right? Maybe you don't have any assets, but this other person you're working with has tons of assets, right? Once you bring on external partners, let's say you get a big contract with one of the biotech companies here and they want you to make 50,000 socks. Well, then before you sign that contract, you want an LLC, because clearly the amount of money that you're making and the amount of risk, if you don't actually do it right, and you've never actually really made socks at that scale before, maybe that's the place where you do it. So look, and all along the lines, the calculus of whether or not how these things change, you're just rethinking them. And at some point you decide that you should form your company. All right. Can you protect yourself if you wait, right? So now it's like me suggesting that it's not necessarily here at 0 where you form it, it's somewhere along this process. And so before you do it, how do you protect yourself? Well, there's 2 ways you can protect yourself. You can practically limit the risk of what you're doing. And so if you have 2 different business models, and one requires you to do something very risky, let's say that it requires you to take on big contracts with big bureaucratic corporate clients, and one just has you selling the thing at farmers markets, well, then maybe you should just sell it at farmers markets. And then at the point where you're pivoting to big contracts, you then form your LLC, right? So this is one way of protecting yourself, by literally limiting the risk of things that you're doing until you have the thing in place to protect yourself. The other thing is contracts, which is the next big point that I'm going to be doing an overview of. And when you have contracts, contracts often have mechanisms for limiting your liability. So particularly contracts that you draft and you give to your internal and external partners. Contracts that you get from other people tend to limit their liability and push liability onto you. And so contracts that you give to other people are generally going to make it so you protect yourself without necessarily having the LLC. But contracts that you get from people are typically going to add more risk to you and change the balance of this triangle again. All right, so let's talk about contracts. So there's tons of different contracts that you might enter into the process of starting your business. And so let's talk about a couple specific kinds. And so contracts with internal partners. So the business partner that you're working with, let's say it's you and a website developer or an app developer. Contracts with your first employees. So although these people aren't necessarily partners, right, they're the types of people who might be necessary in order for you to move forward, right? Necessary contractors. So just like employees might be necessary, you might have a service provider that's necessary. For example, a outside developer. So although they don't work for your company, they have their own business. These developers are the people who are going to do updates to your product. They're going to be the people who troubleshooting to it, etc. And so all of these things are important to have contracts with these people, because contracts let you understand a variety of things. Let's just use agreements with business partners as an example. So the three things that are incredibly important to figure out at the beginning, as early on in the process as possible, so maybe even before you form your LLC, are compensation, ownership, and control, right? Compensation meaning that, hey, I want to start a lemonade stand. You want to start a lemonade stand. Each cup of lemonade costs $1. How much money am I getting? How much money are you getting? And how much money goes back into making more lemonade, right? So this seems crucial to be able to figure out early on, because when the business has no money, everybody is very interested in working something out that makes sense. When the company finally has a glimmer of hope that, like, oh, everything is actually working out, suddenly everyone is very cagey about what their compensation is going to be, because everybody knows that there could be a big windfall. You want to figure that out ahead of time, because that makes everybody, companies have dissolved because people haven't talked about these things before. Something actually like a new event happens, right? Each of these milestones right here is a new event, right? And so you want these contracts in place, so when that milestone actually happens, because it's somewhat unpredictable if it's going to happen, then you can figure it out. Ownership of the company. And so this is often seen as equity, right? There is not necessarily a stock interest in a informal company, right? You buy stocks in corporations, you can't buy stocks in sole proprietorships. And so ownership is going to be, if there's no formal entity right away, it's going to be theoretical, right? When we do form something, how do we own it, right? Because you want to figure that out before you form it. Oh, looks like there's some stuff in the chat. Oh.
It's me.
Okay.
You're good, Shaun. You're good. We've got it going. You're good. You're good.
Okay, sounds good. Let's just keep moving forward then. Control seems like it should be real. How is it different than compensation and ownership? Well, I don't have to own the lemonade stand to be able to say what kind of sugar we should buy and how many ice cubes we need for each glass of lemonade and how tall the glasses should be. And so I don't need to be paid by the lemonade stand to have a say in these things either. And so control is something that sometimes people don't realize is part of the equation, right? Like, control is really important, because if you have one partner, right? Like, it's you and a business partner. If you all disagree fundamentally, then you just have to stop the business, right? Because it is one vote versus another. So imagine for a second you decided that, in the lemonade stand example, I control all of the decisions about the product. You control all of the decisions about administrative things like the bank account, right? So if you have a disagreement about whether or not you should start selling strawberry lemonade, then you know that this person will be the person who makes all product decisions, and strawberry lemonade is a flavor of the product. And so that person wins if you have a disagreement, right? Again, businesses all the time have to dissolve because there are control questions, right? There are questions about who wins if there's a tie between the people who run it. And so this is one of just many types of internal contracts. And so I can't really go into all of these different things, but you can see that these are sort of these fundamental issues that are going to recur in lots of different contracts with people you're working with very closely. All right, so let's talk about contracts with people who are outsiders, so vendors or developers. Let's just use a concrete example of someone who might be helping you develop an app or a website. I imagine a handful of you are going to rely on your website as sort of the communication and maybe even sales platform for whatever you're doing. Maybe you want to start an app and you believe that the app has legs, that at some point it can become a relatively popular app, right? And so I imagine most people come in with a limited technical understanding. And so you're going to have to rely on other people's technical prowess, right? And so that might be, and even if you are a developer yourself, you might bring on another developer who has experience with this particular type of technology or this industry or what have you. And so what should be in that type of contract? Well, deliverables. Okay, so what is it that I am actually asking you to do? What are you selling to me as a service? Because if a developer tells you, oh, I'm making your website, that can mean a ton of different things, because a website is a collection of different parts. Are they doing the front end? Are they doing the back end? Are they delivering files and then you have someone else putting them all together, right? Are they doing design work, right? So yeah, knowing exactly what they're actually going to give you is really important. Timing, right? So when is it that I'm going to get these things? One of the things that people who've never developed an app or a website don't realize is that the vast majority of large, complex development projects always go over time, over budget, and also increase in scope. So if you're writing down some of these concepts to Google and learn more about later, this is often called scope creep. So it sort of, you have one scope at the beginning of the project, and then it creeps along and gets wider and wider and wider, because you realize as the person is making it, like, oh, suddenly this feature would be really great, and this feature would also be really great. And so by the time you actually make the thing into what you predicted, it's going to be a much bigger project. And so making sure that you rein that in contractually by working out the timing in very specific ways. Getting minimum standards for the nature of the product, right? So you don't actually know what you want on some level, because you're not in a technical place to predict what's going to be given to you. However, you know what you don't want, right? And in some ways, that's more important. It's like, I would like a website that works, right? That seems like a good minimum standard for working with a developer. And so if you do your research, and when you're sort of putting together, when you're trying to figure out what's going to be in these contracts, if you're doing it yourself, then you're going to look for, how do I, even if you don't know what it is that you want as the final product, you can add limitations to make sure that the people who are making this for you don't give you what you don't want, if that makes any sense. All right. Technical support. Something else that people don't realize is that you don't just make an app and then it's done, right? You make an app and then the first person uses it and it breaks it for that first person, so you fix it, and then it works for 9 more people, and the 10th person who uses it, there's another fix that you need, and then the 100th person who uses it, et cetera, et cetera. And so technical support is going to be really important, because if you are not actually a technical person, there is no way that you can answer questions that require technical answers. So on some level, you're now in bed with your developer. You're beholden to this person because they actually control your customer experience, right? They are the people who are the gatekeepers to whether or not people get good answers and get on-time answers. And also, once you collect all this information from users about what works and what doesn't work, they're also the types of people who are the people who need to update it. And so when you're thinking about this project, don't just think about, oh, I have $10,000, so I'm going to spend 9,500 of that on hiring a developer, because you're going to realize very quickly that after the development process is over, updates and continuing service to fix bugs and to also provide customer support to people who have technical problems is going to be expensive and time consuming, right? You want to make sure that the people who are helping you develop this stuff are also locked in to helping you later. Because one thing that's also incredibly difficult is, once you created this complex project, to take it from one set of developers and give it to someone else. Because the transition between the two is going to be really expensive and time consuming, because the new developer, developer 2, is going to have to spend a lot of time getting up to speed as to how everything that developer 1 actually created really works. And so making sure that you know that updates and continued payments and continually working with this developer is something really important and something that you won't be able to get away from. Finally, contracts are really important for ownership of the work created. And so if you pay someone $1,000, let's say, to make an app or a website, if that person delivers that app or website next week, you don't actually own it until you have a written transfer of the copyright and the rest of the intellectual property in the work. And that's because contractors own their work. And so, although this seems like a whole technical thing, well, I know that I don't own it from a technical perspective. I did pay for it. This is not actually something that you can rely on, because in the legal world, regardless of whether or not you paid for it, and regardless of whether or not you believe that you own it, and seems like common sense would dictate that you own it, you need this written transfer to actually own it. And so this is one of the worst things that can happen to a company that is really, really valuable based on the IP that is created, right? If your whole company revolves around your app and you don't own the app, well, then what do you own at all, right? And so a lot of companies, when they start formalizing more and wanting to get outside investment, the first thing the outside investors are going to look for is all of the paperwork that substantiates the fact that you actually own all of the IP that you believe that you own. And if you don't, then either you've lost that investment for good because they don't believe that they can trust you, or if you're such a great company that they want to continue to work with you, they tell you that their work with you is going to be contingent on you actually going back to the developers and getting the ownership that you need and getting them to sign the agreement. And what happens there is, as soon as this development company decides, wait a minute, you're going to get a bunch of money now for this thing that we own, they're going to hold you hostage, and they're likely going to create lots and lots of problems for you because they see that you're going to get well compensated for this. So they believe that they should also get additional compensation for transferring the ownership as well. So again, this is one of those issues that you see on the tail end of it, and you should just fix it at the beginning by having a contract with the types of people who make creative work for you. And so this isn't just developers. This is people who make social media graphics for you. This is people who write advertising copy for you. These are people who design the box of your product, right? Anyone who's making creative work, a lot of these issues come up, right? And so these are issues that are going to come up with lots of different types of external partners. And particularly the example that I'm using here is people who are making creative products for your use. All right. Another big overarching topic about contracts is contracts with users. And so two types of contracts with users are terms of service and, let's say, waivers, right? So a terms of service is something that is, you know, when you check that little box that says, I accept, when you sign up for an app or you register for an account. Yeah, so that's the terms of service, and it is a contract between you and the service, whatever you're signing up for. So who knows, Facebook, TikTok, whatever thing you're registering for. And those contracts limit that service's liability. So basically they say, regardless of whatever happens to you on the service, or if the service goes down, or if the service destroys your computer, or if someone scams you on the service, ... we are responsible for none of that. We completely waive all liability for that. And so a lot of this is why every website has a terms of service, not because it's legally required, but it's because it's so good for people who run services and apps and things like that. So there's no reason not to have one, right? And so the question becomes, I guess the takeaway comes, if you are starting a service that relies on a website or an app or anything like that, one of the first things you should do is try to put together terms of service. And one of the most important parts of putting together the terms of service is not just the words that it says, but how it's accepted, right? And so there's rules about requiring people to affirmatively consent. That's why you see those check boxes, right? You have to physically do something to check that you agree. Sometimes you have to physically scroll through something before you're allowed to check. And so all those things are, from a legal perspective, them trying to make sure that you've accepted this thing, and there's no way that you can argue that you didn't accept the thing. And so a lot of people who come to us maybe start out with a terms of service copied and pasted from some other service. And so, again, my perspective differs slightly from many private attorneys. Many private attorneys would say, like, that is blasphemy. Don't copy and paste your terms of service from somewhere else. Like, that'll get you in tons of trouble. And I think that's actually true. But if you were deciding whether or not you're spending, I don't know, $1,000, $1,500 and getting a lawyer to draft your terms of service, or starting your service, then for many people, there's a question of how much risk am I entering into? So my answer is, if you copy and paste the terms of service, you should probably do it from a service that is extremely like yours, number one. Probably a service that is also headquartered in your same state, which is nice because California has a lot of large companies. A terms of service that wasn't itself copied from somewhere else, right? So lots of sites are also just copying it. So a site that might be run by, I don't know, a Fortune 500 company or something like that, where clearly lawyers have looked at it. And then I would say that with that in place, you make sure that you have a robust process for getting it accepted, right? And so you don't just place it on a page on your site and you're done, because it's actually useless that way. You have to, for example, before registration, make sure that people check a box, and so copying the actual acceptance mechanism of the place that you copied it from as well is going to be useful. But that said, I do agree with all the lawyers who are like, that's a bad idea, because yeah, it'll probably, unlike most contracts, which I would say it's very, very difficult and problematic to just take something random from the internet. A terms of service is a unilateral contract, meaning that the other side doesn't negotiate it. And for the most part, much of what makes lawyers writing specific contracts better than just copying and pasting it is that the lawyers will take into account what the other side is expecting and what the other side is going to negotiate, etc. But if there is no other side negotiating, right, there is kind of an like, oh, well, these are all just standard terms and things like that. So, yeah. But still, the terms of service is going to result in copying a terms of service is going to result in it being 20, 30, 40% wrong, right? Because it's not going to attend to your specific issues. It might overreach in some ways. It might be under-inclusive of things that you do that the other service doesn't do. And the problem is you also don't know which 20, 30, 40% is actually wrong, right? It could be a completely non-meaningful 20%, or it could be the most fundamental 20%. And so if you do copy and paste the terms of service, you should go back to this idea, right? It's like, when should you go to a lawyer and figure out when you should draft a real terms of service? Well, the more stuff that can go wrong, the more money that you're making, and the more you have at risk for your business, you should probably think about those things. And then finally, at the point where you are soft launching, right, this is the point where you probably need the terms of service most, but not at the point where you have a product idea, right? Because between your MVP and your actual real launch, your service might change so significantly that you just have to rewrite your terms of service anyway. So who knows, right? And so what I'm doing right here is I'm trying to just give you a like, instead of just saying, do everything that I'm telling you to do right now, and I'm not telling you to do anything specific, right? But think about these things from a holistic perspective and think of it less about like, oh, a lawyer told me to do 10 things, so I'm going to do all 10 things, or I'm not going to do all 10 things because they're so expensive. Think about it as a set of risk and reward propositions, right? If there's a list of 10 things that you come away with, which ones are most helpful? Maybe I should do those first. Figuring out an order of operations based on the types of stages your project is in, and which ones you need first and which ones you can wait for. What can you fix in the future versus what is so fundamental to have in place now that it would be so expensive to fix in the future, I'd rather not, right? Here's another example of a contract with a user, a waiver. So, you know, like those personal injury waivers if you're at a rock climbing gym, or if you're doing some sort of healthcare thing and you have a waiver. Well, here's a good case in point, right? If your business is a rock climbing gym and you decide, well, I don't want to hire a lawyer to write my one-page waiver, and then someone falls and breaks both their legs, that was probably something that you can't fix afterwards, right? You just have to deal with it. And so maybe you should put that very early on your timeline of things that you should work out with an attorney. All right, trademarks. Can't really talk much about this because I'm rushing to get to the end, so we have questions, so I can field some questions. But
I was gonna say, Shaun, I didn't mean to interrupt, but yeah, I just wanted to make sure that we do have a little bit of time for questions at the end. But
okay, please, yeah. Should I just?
No, I would love to. I would actually. I think if everyone's okay with it, I would love for us to at least be able to touch on it, and we'll get to the questions at the end.
All right, sounds good. I can be here for as long as anybody wants me to be here. All right, trademarks. You generally know what these things are. They are the types of intellectual property that are going to protect things like your logo and your name. You get certain trademark protections automatically without registration. Registration for many reasons is valuable. Same question we get typically asked. How do you figure out if registration is worth it? It's that same triangle, right? It's how valuable is the name to your business? So for example, people who sell things that are intangible often rely more heavily on branding, right? Yelp is nothing but its name, right? Like And so how important the name is, how important it is that you might want to avoid people who are suggesting that they are you and being copycats either in your region or nationally, it might be more important. All right, how much could this money and time be used in something more important? So a trademark is something that you can often fix later on, right? Because you do have certain regional and local trademark protections just by using the name. And so if you can fix it later on, it might be the type of thing that you push, and you might form your business first, or you might get your contract situation worked out first, and then work on the trademark registration later if you have a limited amount of money. And then finally, how soon do you need to take advantage of the benefits of registration? And so you can Google all of the different benefits of registration versus having a non-registered trademark. But one of the biggest values of registration is, again, if you're seeking outside investment, because what happens is that if the value of your company comes from the fact that nobody else can use that same name, and you've created a lot of goodwill under your name, then no one's going to want to invest in a company that hasn't actually secured that name, right? And so that's one of the many advantages that you get from registration, which is being able to appropriately go to outside investors and say that you have secured the value of your one of your most valuable assets potentially, right? Food service is the type of thing that often has a really, really large value to its name, right? There's lots of different taco places, but there's only one Taco Bell, right? So if you're scaling into different markets really quickly, so unregistered trademarks have local protection, but if you want to then start doing things in not only San Diego, but also Delaware and Oklahoma and Florida, then you would get large benefits from national registration. All right, employment law, right? There's lots of things that limit the ways that you can employ people and require you to follow all sorts of administrative things about how you pay someone and how much they work and when people are sick, if you have to pay them or not. And so that is an hour-long conversation in itself, but that is also something that if you did want to sign up for a consultation, we could talk about.
I was going to say, Shaun, I'm so sorry, it's Tanya again. I did want to point out also that some of these topics, if I don't know if it's something that you might be interested in doing, but some of these would be amazing follow-up workshops too. So if we don't have time to get to all of all of the topics today, we definitely if you ever want to come back,
definitely. Privacy laws, as soon as you start collecting data, right? Privacy laws govern. And so what does it mean by collecting data? Every state has different privacy laws. California has probably the strongest one currently and might get another one after a ballot initiative this November. But whenever you collect, use, store data, right, these laws make sure that you secure it against the data being breached. By that breach, meaning getting stolen, right? So almost all of the laws generally cover at least security and breach, and they often also cover collection and use. And then a handful collect storage. What does this mean for you practically? If you own any website, you're literally collecting data because almost every website or app is connected to Google Analytics. Google Analytics tells you things like who showed up at the website, when they showed up, where their browser is, what their location is. So literally everyone, just by virtue of doing something, having a service that's online, is probably doing some of these things. But then if you have a registration process on your site, you're doing more of it because now you're collecting names. If you're selling things on your website, now you might be collecting financial information. And so on and on and on. There are lots of different privacy laws, and it's worth making sure that you generally do things like putting together a privacy policy because those things are required by law. And that's something that you can talk to an attorney about. All right. Getting a privacy policy and getting a terms of use. These are both ways to limit the liability of your website, right? We've already talked about terms of use, but getting a privacy policy and making sure at minimum the privacy policy simply says we can do anything that we want with your data, and we will follow all laws associated with the data when possible, right? It's actually much better to be vague in a privacy policy than to be ultra specific and then be inaccurate, because most of the legal liability that comes from privacy policies is you saying something that you don't actually do. So if you're very broad and you say, well, we can do whatever we want, then most of that liability disappears. All right. What happens if you can't hire a lawyer? All sorts of things. There's lots of larger firms that have startup programs. You could sign up for one of those. So I'm sure like Shepherd Mullen, Latham Watkins, all of these large IP and startup firms, they have these programs. They're application only, but I think that they're open to a lot of people who might have like a viable business. They're probably less interested in businesses that are local in nature, mostly regional in scope, not necessarily tech related, but who knows. Self-help. So you've written down notes here. Now you can start Googling stuff. You can buy a book like Don't Panic. You can look at Wikipedia for all of this information. There's just a lot of information that you can use to your advantage, right? If you want to do it yourself. There's also pro bono legal programs. So like New Media Rights is one. There are a handful of legal clinics across the state and the country that also work with law students who have low or no fees, who might be able to help. If you want to contact us, we have lists of those people. So even if we can't do anything about it, we can always pass you on to other people. And then finally, there's private attorneys, some of whom cost less than others. Just to answer the question, when should I talk to an attorney, right? Again, there's lots of different spaces on this process, right? Hopefully you've already talked to an attorney to prevent some issues before the soft launch, but at some point on this process, and we don't have enough time to talk about it, attorneys become increasingly valuable. All right.
And oh, sorry, Shaun, can I just say, I know that some of the students do need to leave for finals, and for those who do need to step away, we appreciate you coming. And I think we're going to be wrapping it up here shortly, but I will share you the recording. So we will have time to answer some of the questions that you put in the chat. And so you can see those answers in the recording if you do have to leave to get to a class. But we thank you, those of you who need to leave.
And if this was exciting, well, you can get an hour more of this specific to your issues and sort of your industry. And so feel free to sign up for our consultations on this bit.ly link. It'll bring you to Calendly, and then you can sign up for one of these days. There's only 3 spots per day. So feel free to hit us up at that address. You can also contact us if you're just asking a specific question. Go to newmediarights.org. We have a contact form there. We can answer your specific question, even if you don't necessarily want a 1 hour more general consultation about your business.
Awesome. Thank you so much, Shaun. So we will just, if you still have time to stick with us, Shaun.
I'm here.
Those questions. Great, wonderful. And then, so I had
it's not like I'm going anywhere. Like,
I know, right? You know you're at home, right? But no, we really appreciate you spending so much of your time with us. And honestly, for me, it's so refreshing to hear a lawyer say something like, when you were saying like to copy terms of terms of service. No lawyer would ever say that.
Well, I've never heard. Yeah, because you just see it, like everybody who contacts us, right? It's like 95% of the time they've copied and pasted a terms of use. It's actually funny the way that I talk to, so we work with law students every semester who are learning how to do this type of thing. And I'm like, all right, here is where you make your money as an attorney, because either you can not see any problems with this, and then copying and pasting this terms of use was essentially as good as you doing it yourself, or you can identify the nuanced situations where the things that are copied and pasted do and don't work. And so it's really important to, I mean, just from my perspective, training law students to understand that, like, you are also competing against the idea that it's very easy to now find this language, right, and do it yourself. And so you need to be better than that. And some attorneys are not better, right? Some attorneys are not. And so that's also another question, right? Like, do you pay for an attorney who then gives you another copied and pasted terms of use?
Sometimes it feels like that. Sometimes it feels like that. It's, again, refreshing to hear an attorney actually say that, but yeah, kind of
Hey,
shocking.
Shaun.
Thank you.
Hey, Shaun, this is Brennan.
Yep.
I've got a question for you.
Go ahead, Brennan. Go ahead, Brennan.
So I saw something, I was in a workshop recently, and I saw the slides had, like, it said copyright at the bottom, I think. And I was wondering if, like, maybe you could, like, quickly maybe, or just give a short description of how copyright works, if I could use that for, like, multiple things, if I can, like, somehow set up a copyright, because I like to make, like, flyers and maybe a training program and stuff.
So one of the really exciting, nice things about copyright is that you don't actually have to do anything except for make a creative work in order to have a copyright. And so let's say you made a flyer, for example, and you made an illustration that you turned into a flyer. So at the point where you've done this, you've already secured a copyright. And so to the extent that you want to give notice of the copyright or you want to register the copyright, it could give you additional benefits. And so what you were talking about, seeing on the slides, like the little notice, like the circle C, and then it has a name, that's called a copyright notice. And so that used to be required for you to get a copyright, but not anymore. And so the thing that it does now is that it puts people on notice that this thing is copyright protected, such that if there is a dispute, then it's easier to prove the dispute. And so imagine first, it's not necessarily going to create a situation where you have a better copyright because you don't need the notice. However, imagine for a second that it makes it easier for you to find a lawyer to take your case, right? It makes it easier. It makes it much more likely that if someone copied it, then they would settle with you rather than ignoring your outreach. And so that's one of the things that the notice does. And then finally, registration, which is typically $55 per work. It's something that in some situations you can do yourself. In some situations, you're going to want a lawyer. Registration gives you the power to get what's called statutory damages. And so imagine for a second that, let's say that I wrote a screenplay. And so that screenplay got copied, for some reason got used by some sort of large production company. And so now they made a movie based on my screenplay. Well, if it was not registered within a certain period of time, so 3 months of publication or before the infringement happened, then you can only get actual damages. So you pretty much get the amount of money that movie will make based on your screenplay. However, if you have a registration within 3 months, then you get statutory damages as well. And so statutory damages meaning that you get $150,000 per infringement, right? So regardless of however much money the copying made, right, you still can get up to $150,000. And so why that's important is not because like of large infringements like that, it's because of small infringements. So if you're a photographer and you have one photo that happens to be copied by some stock photo website, instead of asking for the $15 that they made selling the photo, you can demand that they send you $150,000, right, plus attorney's fees. And so that is the type of thing that A, gets a lawyer to want to take your case, and B, makes the other side very willing to settle their case instead of just ignoring you. Because most people know that no one is going to actually file a lawsuit over $28. But as soon as you argue that you can get not only $150,000, but also attorney's fees. And so this is critical, because once you win, the lawyer who is charging $300, $400, $500 an hour will get all their money back, right? Then this makes it more likely that the lawyer will take your case and the other side will take it seriously, and then you'll get money. And so, yeah, I think that the
I was just going to say,
yeah.
thank you. That really clarifies it for me. Sorry.
Hey, Shaun.
Mm-hmm.
Thanks for the whole presentation, too.
Oh yeah, no worries. No worries. Any other questions?
Yeah, I had another question for you from the chat room. So if somebody this is from Jean-Baptiste Fical, if somebody like a contracted virtual yoga teacher is it by default that yoga teacher owns the rights to all of the video recordings of them teaching, and then the studio cannot reuse the videos unless there's a written transfer of ownership? Is that true or not?
Okay, so it depends on a lot of factors, but the biggest factor is whether or not the yoga teacher is an employee or a contractor. And so this is actually a much more complicated question in California as of January 1st, because of the new AB5 rule, which assumes that many people who work for businesses are now employees and not contractors. So most people tend to want to be employees because it gives them a lot of employee benefits. It gives them, in California, sick days, lots of different benefits of being an employee. But one of the downsides of being an employee is that all the creative work that you make during the course of your employment, right, using the company's equipment, for example, is going to be owned by the employer. Whereas with a contractor owns all of their stuff. So remember, I was talking to you about the contracts with website developers. The last part of it is making sure you own the work. And so the same thing would be true of someone who's a contractor who has a bunch of different yoga curriculum type of things that they bring to a studio, right? If that person is a contractor and there's no contract saying that that work was assigned, then that person continues to own it, right? And so the question, so there's two directions that this could go. There's one direction where this person is clearly an employee or clearly a contractor. But there's also the direction where this studio, because they want to save money, says that this person is a contractor, when really, based on the law, this person is actually an employee. And so this is one of those nuances where if you were actually an employee, then you don't own the yoga stuff, but you are entitled to a bunch of back pay. If you are a contractor, then you're not entitled to back pay and all these other benefits, but you do own your stuff. And so in that gray areas where lawyers make a lot of money, because then they present this issue to the yoga studio, and then they get a settlement with the yoga studio that either allows the person, if they wanted to own the curriculum, to own the curriculum, or if they wanted to get back pay, to get some of that, and maybe they own the curriculum too as a part of the settlement. And so, yeah, it's a question with a lot of open-ended facts, but
that might be. I was going to say that might be one of those questions that it would be helpful to know the specific details of that.
Right. Yeah. So yeah, it's like one of those things where like the answer starts becoming a little bit more straightforward when you have like, how long did you work there? Give me all of the employment paperwork that you got from me. And so this is what a lawyer would typically do if they're starting to answer that question in a specific way.
So I think, we don't have a whole heck of a lot of time left together. I know a lot of you have classes to go to, but I did see one question, if we could quickly answer it from the chat. It was a question it was from Ethan. Thank you, Ethan, for writing that question. He wrote a one-act play about a character who is wearing a Make America Great hat. And he wanted to know, his question was about, can he actually use that slogan? Is that such a ubiquitous slogan? And because the character of Donald Trump, I would suppose, is a public figure, can he use slogans like this, or do they still have that protection?
So this is one of those questions that I think would be a really great question to ask in our newmediarights.org contact form. And so this is the type of question that we answer quite frequently. It's actually overlapping with a lot of issues that we haven't necessarily talked about, right? Trademark law, rights of publicity. So to what extent can you portray someone who's like a personality, right? Defamation, all of those different types of things. So I would say it's going to be very difficult using some of the information that we spoke about here to answer the question in a meaningful way that makes sense to anybody else watching, except for the person who answered the question.
No, that makes sense.
I would say generally, right, like fashion doesn't really get very much protection under IP law, so wearing a hat is not necessarily going to trigger like a copyright issue. Wearing a hat with a slogan on it, if you're not intending on selling those hats, might not create a trademark issue. Impersonating someone, particularly who's a public figure, is likely to be okay, right? I mean, we have Saturday Night Live impersonating people all the time. Selling things based on someone else's likeness, is somewhat problematic, but less so when it's some sort of public figure. So yeah, lots of different issues there.
Yeah, a lot of issues with the one issue. All right, so I think we better wrap it up there so the rest of you can get going. I want to thank you again, Shaun, for coming. I really appreciate everyone. We're going to have more of these, so don't worry, your questions will get answered. And as Shaun was saying, there are 3 events that we have set up where you can get that one-on-one guidance from New Media Rights. You can also, those of you who are with me, and most of you looks like are, can always reach out to me and we can set that up as well. Thank you all for being here. It was, as usual, amazing. And good luck in finals.
Yeah, thanks for the great turnout and good luck with all your finals and everything like that.
Thank you.
I'm glad that I'm not taking any tests.
Thank you.